Welcome to The Defense Rest, the podcast where we explore the captivating world of criminal trials through the lens of an actual criminal defense attorney. My name is Rachel Diane, and I'm your host. In this podcast, we dive deep into the intricacies of criminal trials, the tactics that are used by the prosecution, the strategies that are explored by defense attorneys, and the very critical decisions made by judges that shape the outcome of a trial. And for all of those that are listening through the podcast, just so you know, if you would like to follow along visually, you will be able to also watch me break down this trial on YouTube. While I'm on YouTube, I use a lot of visual aids, so images of the prosecution, of the defense, the judges, as well as the witnesses that are called to the stand. I also put in a lot of images of the actual evidence as well. So of the evidence that is presented at trial, whether it's recordings, pictures, anything, it's also inserted into the YouTube video as well. So you're able to visually follow along and see what the jury actually was presented as well. And while I'm breaking down these trials on YouTube, I'm also doing my makeup at the same time with makeup from my own company, Royalty Cosmetics. A portion of all proceeds of the makeup that is purchased goes towards free legal aid and free legal defense for women that were victims of sex trafficking that are now facing prosecution by the government, as well as for minority children living in inner cities. You can purchase at www.myroyaltycosmetics.com. And today, under the legal lens, is going to be the People versus George Zimmerman, Part 1, also known as the murder of Trayvon Martin. On February 26, 2012, at 7:09 p.m., a man by the name of George Zimmerman called the non-emergency 911 Sanford Police Hotline. He was calling to report a suspicious black male that he believed was on drugs or up to no good because he was walking in the rain, looking at houses.
Hey, we've had some break-ins in my neighborhood, and there's a real suspicious guy. It's Retrieve Circle. The best address I can give you is 111 Retrieve Circle. This guy looks like he's up to no good, or he's on drugs or something. It's raining, and he's just walking around, looking about. Okay, and this guy, is he walking on Cosmetic? He looks black. Did you see what he was wearing? Yeah. A dark hoodie, like a gray hoodie, and either jeans or sweatpants and white tennis shoes. He's sitting around, he's just staring. Oh, he's just walking around the area? At all the houses. Okay. And now he's just staring at me. Okay, he said it's 1111 Retrieve or 111? That's the clubhouse. That's the clubhouse. Do you know what you near the clubhouse right now? Yeah, now he's coming towards me. Okay. He's got his hand in his waistband. And he's a black male. Okay. How old would you say he is? He's got a button on his shirt. He weighs teens. Late teens, okay. Mm-hmm. Something's wrong with him. Yep. He's coming to check me out. He's got something in his hands. I don't know what his deal is. Okay, just let me know if he does anything, okay? Yeah, we got him on the way. Just let me know if this guy does anything else. Okay. Get down to always get away. Yeah. When you come to the clubhouse, you come straight in and make a left. Actually, you go past the clubhouse. Okay, it says on the left-hand side from the clubhouse? No, you go in straight through the entrance, and then you make a left. Yeah. You go straight in, don't turn and make a left. Shit, he's running. He's running? Which way is he running? Down towards the other entrance of the neighborhood. Okay, which entrance is that he's heading towards? The back entrance. Are you following him? Yeah. Okay, we don't need you to do that.
So a few minutes after this 911 call, several other 911 calls came in as well, and they were all reporting of this fight that was breaking out in front of their houses in their neighborhood, or 911 calls reporting of hearing people screaming and begging for help. And there was one specific 911 call that played a huge role in this trial, because in this 911 call, you were able to hear a commotion going on outside, and specifically you were able to hear someone with a more high-pitched tone screaming for help. You then hear a gunshot go off, and then the cries for help dissipate and they stop. Police arrived relatively quickly after this unnamed person was shot. They say that they arrived within about 2 minutes after the gunshot went off. And when they got there, they saw one person that was face down on the floor in the grass, and they found another person by the name of George Zimmerman that was standing up and above this deceased body. George Zimmerman was taken into custody that night by Detective Chris Serino, and he was questioned for about 5 hours. And after the end of this 5-hour interrogation, he was let go and he was released without any charges. And he was just asked to meet up with the police the next day at the crime scene in order to do a walkthrough and a reenactment of the crime that he alleged happened. Police still did not know who was killed, right? They had no idea who the other person was that was shot to death. But the next day, there was a missing person report that came in by the name of Trayvon Martin. So they called Trayvon Martin and they asked him, hey, we just got this police report of a missing person from you. Who is this? And he said, it's my son. They said, what was your son wearing? He said, sneakers, jeans and a hoodie. And they were like, okay, well, is your son white, Hispanic, or black? And he said black. So police officers then went over to where Tracy was staying, and he was staying in the Twin Peaks neighborhood, gated neighborhood, at his fiance's townhome. And when they met with Trayvon Martin, they showed him pictures of the deceased body from the evening before. And Tracy gave a positive identification that that kid that was being shown to him was his son, Trayvon Martin. At the same time that Trayvon Martin was talking to the police in the Twin Peaks gated community, identifying that the victim was in fact his 17-year-old son, George Zimmerman was also in Twin Peaks gated neighborhood, meeting up with the police to do a reenactment of what happened the night before. This happens quite frequently. A lot of times police officers will take people that have copped up to being the murderer, people that have copped up to being the person that ended someone's life, whether it's in self-defense as George Zimmerman is trying to claim, or whether it's just a serial killer admitting to his murders. They will have the murderer or the assailant go with them, and they'll be recording the entire thing. And as the person is talking about what happened, the police will literally take every drive, every turn, every step, every movement that this person is saying and have it recorded. George Zimmerman was in the cop car with the police officer, and he was telling Serino, like, hey, there has been a lot of issues in this neighborhood recently of a bunch of break-ins and burglaries. So I thought it was really suspicious that I saw this kid in his late teens who's black. I thought it was really suspicious of him to be in this neighborhood. I've never seen him before. I don't recognize him. And I thought what made him really suspicious was that he was standing in the rain and walking in the rain leisurely and like looking at houses, because if you're in the rain, like, why wouldn't you walk fast? So George Zimmerman said that even though he thought Trayvon Martin was suspicious, he decided to like keep driving past him and not stop, but kind of keep an eye on him. But when he noticed that allegedly Trayvon Martin was like staring him down, he became more suspicious of him. And because Trayvon Martin allegedly kept staring at George Zimmerman, that's what made him stop. And he stopped near the clubhouse. So from here, George Zimmerman says that after he stopped at the clubhouse, he called the non-emergency police line. And that the non-emergency dispatcher asked him like, hey, well, where is this kid going? Like, what direction is he going? And that he told the police officer, the dispatcher, that he said, I don't know, I've lost sight of the suspect. And Zimmerman then tells the detective that the dispatcher says, okay, well, can you go find him? And can you go let me know where he's at? Now, you listen to the 911 recording, so you're gonna hear a lot of these inconsistencies with what George is saying the next day, right? So George tells the dispatchers that it was someone in their late teens. He's now telling detectives and his lawyers in the world that he thought who he killed was 28, that it didn't look like a teenager. He also is saying that he didn't choose to follow Trayvon Martin, that dispatchers told him to, because dispatchers wanted to know where he was going. But you heard on the recording that the dispatcher never said that and specifically told him to stop following Trayvon Martin. After George Zimmerman tells Detective Serino that dispatch asked him to walk somewhere and find Trayvon Martin and let them know where he's at, he says that he's now somehow back in his car after trying to find Trayvon Martin, and that he sees Trayvon Martin in the distance cut behind some houses. He says that he loses sight for him a little bit, and then Trayvon Martin comes back out from behind those houses, cuts back in behind the houses, then comes back out yet again behind these same houses. George Zimmerman then says that Trayvon Martin, after cutting back and forth between these houses, comes up to George Zimmerman's car and starts circling it. And then after circling his car, that Trayvon Martin just disappeared. And if you watch the recording of this, and you can, it's not very long, it's about 45 minutes. If you watch the recording of this from where George Zimmerman is parked, right, it is literally impossible to circle the car and then just disappear. You would be able to see where the person went. It is relatively very open with nothing around. You would see every direction, a 360 view of where someone would walk off to. George Zimmerman then tells the police, after Trayvon Martin disappeared, I decided to get out of my car and find the closest address to give to the dispatch because I didn't know what address I was at. And if you listen to the 911 recording, the one I just played, that is false. He knew exactly what address he was at. He said that he was parking at the clubhouse. He gave the exact address of the clubhouse, and he was still in his car at that time. We know that because it's not until about a minute and a half after he gives the address that you can hear the car make that kind of alarm noise sound of when you open the door and the car's still running. But he's telling Officer Serino that, hey, I didn't know what address I was at. Dispatch was asking me for address. They said that I needed the address, so I decided to get out of the car and find it. He says that he then walked, instead of looking at the address at the clubhouse where he was parked, that is very clearly marked with an address, he says that he decided to walk completely across the complex to a home that is literally probably a 5 to 7 minute walk from where he was parked to get that address. So if you look at the recording, you will see that George Zimmerman is parked in front of a clubhouse, and there's a bunch of townhomes that are all around this gated area. And there's a big open field of grass in between the townhomes, and there's a sidewalk that goes through this grass. And if you walk straight across that, you can see that there's a street on the other end and more townhomes. It's your typical gated complex. George Zimmerman then tells Officer Serino that after this point, after he walks the 5 to 7 minutes to get this new address, that he tells dispatch that he cannot see Trayvon Martin at all, that Trayvon Martin has disappeared. And so police ask, okay, do you still want us to come down here? And Zimmerman says, yes, I still want you to come and check it out. Then Zimmerman claims that when he was halfway back to where his car was, that Trayvon Martin literally jumped out of nowhere. He says that Trayvon Martin literally popped up out of nowhere when he was walking back to his car. Now, if you look at the recording and you look at exactly where Zimmerman was standing when he alleges that this happened, you'll know that it's impossible. Because, again, like I said, what happens is that the police are recording and making you go through step by step of everything that happened. Like, they will literally ask you, is this the exact location? Is this exactly where you were? And they get confirmation with every single step that you take. And where he was saying that Trayvon Martin jumped up out of nowhere and he popped out of the bushes, it's impossible because there's not a single bush in this neighborhood and in this area. There's also not a single tree to hide behind. There are about a few trees that are planted about anywhere between 12 to 13 feet away from each other. And they're single small trees. They're probably not standing more than 7 feet high. And they're probably not more than 6 inches wide. And it's winter, it's February, so there's no leaves on the tree. Like a squirrel couldn't even hide behind this tree, right? Zimmerman then says that after Trayvon Martin popped up out of nowhere, that Trayvon Martin said to him, "Do you have a problem?" And Zimmerman responded with, "No, I don't have a problem." And that Trayvon then told him, "Well, you have a problem now." And Zimmerman claimed to Officer Sereno that as Trayvon Martin said, "Well, you have a problem now," he was reaching for something in his waistband and holding something in his waistband. He said Trayvon Martin then punched Zimmerman in the face. From there, Zimmerman says that after he was punched in the face, Trayvon Martin then got on top of him and just started wailing on him. He said that he started crying out for help, like screaming out for help, and that nobody was coming to assist him, and that Trayvon Martin had now grabbed his head and began slamming it violently on the concrete. He says that Trayvon Martin's knees were about at Zimmerman's chest to armpit area, and that Trayvon had grabbed his head and was picking it up and slamming it as hard as he could multiple times onto the sidewalk, onto the cement sidewalk, and that his skull felt like it was on fire. Zimmerman then claims that he was able to kind of wiggle his way to move Trayvon Martin, who was on top of him, and his own body 10 feet away from the concrete onto the grass. He says that after he did this, that Trayvon Martin covered his nose and his mouth and said, "You're going to die tonight, bitch." And then he felt Trayvon's hand go down Zimmerman's side, and what Zimmerman thought Trayvon was reaching for his gun. And therefore, Zimmerman grabbed the gun first and shot him. Zimmerman then says on the recording that at first he didn't even think that he actually shot Trayvon Martin. He didn't think that he actually got him in the chest, because he says that after he shot Trayvon Martin directly in the chest, and again, according to his statement, Trayvon Martin would have been on top of him, bending over and like hitting him, and that George Zimmerman would have gotten his gun from his waistband and shot him in the chest, meaning that Trayvon Martin would have been shot point blank, right? And so he says that he didn't even know he shot him at first, because Trayvon Martin didn't fall over. Instead, Trayvon Martin like sat up and sat back, and I quote, okay, I'll stop now. You got me. So in the video as well, you can see in the area where George Zimmerman was saying that he was attacked, and the concrete where he was showing that his head was slammed against multiple times, you could see that there was absolutely no blood there. There was no blood on the concrete. There was no blood on the grass. The only blood that was on the grass was where Trayvon Martin's body was when it was laying face down in the grass after being shot. So in addition to questioning George Zimmerman the night of the murder, and as well as doing the reenactment, the police brought him back in to do something called a voice stress test. It's basically like a lie detector test, but it is trying to get the patterns of the stress within your voice when you're giving answers, which, by the way, is exactly what a lie detector test is. So he was asked 9 questions and only 9 questions, and none of the questions were related to race. He was asked if the wall was green, which he said no. He was asked if his name is like George Zimmerman, which he said yes. And then he was asked, were you in fear for your life when you shot Trayvon Martin? Which he responded, yes, I was. Now, he said yes before the question was even finished. All what was said was, were you in fear? And he said yes. And the questioner was like, you need to let me finish. Were you in fear for your life when you shot Trayvon Martin? And George Zimmerman said yes. After the 9 questions were done being asked, he passed the stress test. So he passed the lie detector test. And so the police were like, okay, he's obviously telling the truth. He passed this lie detector test. And so we're going to let him go. And by the way, there's not a single lawyer alive that finds any credibility in lie detector tests. They are infamously unreliable. The police concluded that Zimmerman was telling the truth and that he acted in self-defense, and he acted under the statute in Florida that was called the Stand Your Ground statute. So they decided to not do much more investigation into this case, as this was case closed. No crime had been committed here. This was a lawful killing and self-defense. But on March 12th, this story had begun to get out, and the public had begun to hear about this story. And therefore, the Sanford police chief, Bill Lee, he actually gave a press conference because of the public outcry and anger. And he said, and I quote, "Until we can establish probable cause to dispute Zimmerman's claim of self-defense, we don't have the grounds to arrest him." Now, I know this sounds really weird, right? Like, why does it sound like this cop is cosplaying as a lawyer? And that is because the Florida statute of Stand Your Ground literally allows the police officers to act as lawyers. In fact, many Florida district attorneys hate this law. And the reason why they say they hate this law is because it gives the police so much power that they're now also prosecutors, that they are the ones that are going to be in charge of deciding if a crime should be filed or not, or charged or not. And that is really only up to something called the charging deputy, which is a very specific district attorney. By mid-March, there has been no arrest of George Zimmerman, and there has been no progression on this case. So the Martin family decided to hire a civil rights attorney by the name of Benjamin Crump. And he is one of the biggest civil rights attorneys out there. He is massive, and he is probably one of the best at his game. So they hired this attorney, and he was able to not only get the 911 tapes released for the entire public to hear, as well as the Martin family, but he was also able to bring the mainstream media onto this case. So much so that a law student created a change.org petition asking for the arrest of George Zimmerman, and it got 2.2 million signatures. Because of this like insane public outrage, as there should be, by March 22nd, Bill Lee, the Sanford chief of the police department, was put on immediate paid leave. And what happened was that the governor in Florida appointed a special attorney by the name of Angela Corey. She was a state attorney. He hired her on to be a special prosecutor to look at this case with an quote unquote unbiased point of view and look at all of the evidence, do her own investigation, and decide if any charges should be brought. Now, people really do think that this was a very strange district attorney to bring in as the special prosecutor. And the reason why is because Angela Corey has a very, very bad reputation in the state of Florida. She actually has the reputation of overcharging people of color, specifically people of the Black and Hispanic community, of overcharging them, and during sentencing, arguing and requesting for the maximums. Right? She also was the first person in Florida history as a prosecutor to charge a 12-year-old Black boy as an adult for murder. A 12-year-old child who got into a fight with his brother, and in the fight with his brother, he hit his brother in the head a few times and the brother died. right? So she decided to charge this 12-year-old as an adult. She also was known as the prosecutor that refused to give the stand your ground defense to an African-American woman who shot 3 shots in the air in her home as a warning signal to her abusive husband that had just beat the living shit out of her and was trying to kill her and her daughters. And that woman got 20 years, the maximum per count, which was 3 counts. So I believe it was 60 years total for shooting 3 warning shots in the air. So again, it was very weird that she was the special prosecutor that was assigned to this case, because she has a history of discriminating against people of color. DDA Corey began her independent investigation, and on April 11th, she announced that she was charging George Zimmerman with second-degree murder and that he was currently in custody and he was going to wait formal prosecution. On April 20th, George Zimmerman was released on a $150,000 bond. So he only had to pay $15,000 of that. You only pay 10% of whatever your bail or bond is, right? So if your bond is at $1 million, you pay $100,000. If your bond is at $100,000, you pay $10,000. So he paid $15,000 and he was able to be released on his own recognizances with an ankle monitor. And the reason why his bail was set so low was because at the bail hearing or at the bond hearing, his wife testified under oath, under the penalty of perjury, that they had absolutely no money and that George was the provider for them, and that because he hasn't been able to work between April 11th to April 20th, they have no money and they can't make ends meet and they can't make their bills, etc., etc. So when something like that happens, like, bail is supposed to be given to you in accordance to your income, in order to avoid excessive bail, right? Which is unconstitutional. You cannot give somebody an excessive amount of bail. But that bond didn't last for long, and George Zimmerman was put back into custody. And the reason why was because the district attorney got their hands on all of the recorded jail calls between George Zimmerman and his wife. And just so you know, when you are in custody and you're making a phone call, there is literally a recorded voice that says, everything you're saying is being recorded and it can be used against you. They're telling the truth. Okay, that recording is literally telling the truth. The amount of clients that I get in that I think we have a reasonable defense and that we have a shot at winning or getting a really good plea deal, then the district attorney sends over discovery of their jail calls. And I'm like, well, we don't got shit anymore. Whatever. So the district attorney got a hold of these calls and she started listening to them. And what she discovered was that the Zimmermans were lying. In fact, she realized that they were talking in code. So when he was talking to his wife, they kept referring to something as Peter Pan. And they kept referring to this amount of money, and that was under $10,000. But they kept referring to a number and in correlation to Peter Pan. So they weren't necessarily saying money, but they kept saying 9,999 Peter Pans. And the district attorney was like, what the fuck? Like, what the fuck does this mean? So she subpoenas their bank records, because your bank accounts will never be flagged if an amount is under $10,000. The only time it's ever going to be flagged is if the amount is over $10,000. So the district attorney would be notified of any amount going into your bank account that's over $10,000. So she looks and there's a shit ton of deposits into their bank account for $9,999 from PayPal. So then she does some more research and she finds out that a whole bunch of white supremacists are donating hundreds of thousands of dollars for the defense of George Zimmerman. And also on these recordings, George Zimmerman had to give his passport over, right? He wasn't allowed to have a passport because you don't want to be a flight risk. So on these recordings, they find out that his wife actually got him a second passport that the government didn't know about and hid it in a safety deposit box. And it really sounded like he was actually going to try to flee the country. He had these hundreds of thousands of dollars now from white supremacists, and he got a new passport. And you could hear on these recordings that he was very, very, very concerned about getting a new passport. It was like one of his biggest priorities. He was brought back into custody and he was given another bail hearing. So he was released on April 20th, and then in July he was back in custody and he got another bail hearing. And at this bail hearing, all of this was presented. The passport, the lies, the codes, the PayPal accounts, all of that. And the judge still granted bail. Except for this time he granted bail at $1 million. So he had to pay $100,000 of that in order to get out on bond, which he did. He had more than enough money from all these white supremacists that were donating to him through PayPal. So this is where it's going to get really crazy about the law that you're about to learn about. So we're going to go back to the stand your ground defense in the state of Florida. What the stand your ground defense basically was that it allowed people and officers to claim and conclude that you're not guilty of something because you were just standing your ground. You were just defending yourself. And a jury doesn't decide that, and the prosecutor doesn't decide that. No, you just get to claim it, and therefore it's kind of true. Let's explain a little bit further. This allowed a person in the state of Florida who reasonably believed it was necessary for them to use deadly force to prevent serious bodily injury to themselves, that they were allowed to use that deadly force without retreating and without matching force, right? They could use more excessive force than what the other person was using against them. The law also provided that if a police officer, right, if a police officer did not listen to a person's claim of the stand your ground defense, then that police officer would be civilly liable and could be sued by the person that killed someone else. And they could lose their job because they did not listen to someone that said, I stood my ground. So if you look back on like the research and you look back on the cases that were happening with stand your ground, it was literally like two people got into a fight. Like this is a legit case, just so you know. Two people got into an argument and they got into a fight. They started pushing each other and they both fell into the water in Florida, right? So one person was trying to get out of the water and the other person got angry. So while they were still in the water, they pulled their gun out of their pocket and shot the person in the back of the head and killed them. But they didn't go to prison because it was stand your ground, even though the person's back was literally facing their front. It's insane. And also the statistics show in this that it was like 73% of the people that were claiming stand your ground and were granted stand your ground were white. So they didn't get prosecuted. And it also was showing that it was like something like 59%, 60% of people that claimed stand your ground and killed a black person also did not get prosecuted and could use stand your ground defense. So the other thing that was very interesting about stand your ground was that it literally gave you immunity from being prosecuted. This is the most insane thing because I have literally never heard of this in my life, right? So what would happen is you would get arrested and you would claim to the police, hey, I was acting in self-defense based off of the stand your ground statute. So then what would happen would be that you would go to something called a pretrial hearing in front of the judge. With no jury, nothing like that. And this was just a pretrial hearing to hear your evidence and your argument on why you qualify for stand your ground, right? And if the judge agrees with you, you are granted immunity and you could not be prosecuted for killing somebody. Now get this, this is the best part of it all about this law. The pretrial, right? The pretrial hearing, do you want to know what the evidence was based off of? A preponderance of the evidence. Did you know that is the absolute lowest form of a burden to meet? It's the absolute lowest burden to meet. Let's just go over some of these burdens really quickly. There's beyond a reasonable doubt, which is the hardest standard of law to prove, right? It has to be proven, every single element has to be proven beyond a reasonable doubt. Now we'll go to the next one. Clear and beyond doubt. So clear and kind of like convincing. This is applicable for removal proceedings. So clearly and beyond doubt is not as high as beyond reasonable doubt, but it's for removal processes. So when somebody is going to be deported, You have to have like clear and beyond just a doubt, not a reasonable doubt, just a doubt. Then you get into clear and convincing evidence. This is a lot of civil issues, right? This is based off of marriage proceedings, and it's also based off of removing your child. So if the government was going to take your child from you, so like dependency or even some forms of deportability, they have to meet this burden of clear and convincing evidence. And then at the very bottom is the preponderance of the evidence. This just means you need a 50.0001% that what you're saying most likely happened. Literally, you literally just need 50.001% chance that what you're saying stands up. And then you don't get prosecuted for murder. The defense was going to argue the defense of stand your ground, right? They announced that in August of 2012 that was their defense, and that was what they were going to go in front of the judge and argue for, but it actually never happened. So the defense attorneys decided against it, and George Zimmerman waived his right to a stand your ground pretrial hearing. And the reason why the defense said that they waived this hearing and they decided to not go forward on this argument was multiple things. The first one they said was that they don't believe that this actually qualifies because George Zimmerman didn't even have the option to retreat, right? The next thing was that in order to do this hearing, the defense kind of has to lay out their defense. Right? They have to make this argument to the judge, and the DA is going to be there to argue against it, right? And so Mark O'Mara, who was the main defense attorney for George Zimmerman, said he didn't want to risk going to this pretrial hearing and losing and then having the district attorney know their entire defense, right? Now, granted, the district attorney is going to find out the defense regardless because of reciprocal evidence. So they're going to find out that he's just arguing plain and simple self-defense. As you'll hear throughout the trial, although the defense was just arguing regular self-defense and not stand your ground. Stand your ground was mentioned multiple times during opening and closing. In fact, it was even given in the jury instructions. So now it brings us to the month of June. And in the month of June, this is when jury selection or voir dire had begun. So they first started off jury selection with something called questionnaires. Now, questionnaires is very, very common and very high stake felonies such as rape, child molestation, and murder and torture and mayhem. And the reason why is because these are such serious crimes that if you were to voir dire properly on this, you would be there for the next 3-4 months. It would be impossible. So what happens is you have to prepare your own questions called a questionnaire, and you give it to these potential jury members and they fill it out. And this way you can begin eliminating people for cause and for bias, right? But it was really weird because I actually looked at the questionnaires that the defense had given out, and it was literally only 6 questions. And it was pretty much just have you heard of this case? Have you picked a side? Stuff like that, which are obviously good questions because it was a highly publicized case and you want to get a fair trial, but it was literally only 6 questions. And that to me was the weirdest part of it, because usually with murder, especially very big murders, the questionnaires are extensive. So finally on June 20th, a jury was selected. And this is, it blew my mind. So I hope it blows your mind because I don't know about Florida law. I had to do a lot of research. A jury was selected, and 4 juries in Florida, 4 misdemeanors and felony criminal charges. It is only a jury of 6 people and you have 1 alternate. This blew my mind. How that is not a constitutional violation of a fair trial is beyond me. 6 people? 6 people. 6 people. That blows my, how, that just is a huge, that has to be a huge constitutional violation. How they're getting away with that is blowing my mind. The only time that they ever have a 12-person jury is in capital cases. So on June 20th, an all-white, all-female jury was picked. So 5 women identified as white, and the 6th woman identified as mixed race. She was white and Hispanic. And what blows my mind here is how the district attorney did not object to this jury. So when you go through voir dire, it is very tricky. You have a certain amount of strikes for a cause, right? It's unlimited. As long as you can get to cause, saying why they should not be there for cause, you have unlimited amounts. Then you only have a certain amount of preemptory strikes that you're allowed to have. And this is just striking people because you don't fucking like them, right? Because jury selection is a game. It's why many private attorneys who have clients with a lot of money will spend tens of thousands of dollars on hiring jury experts that will come basically stalk the jury, know everything about them, and pick the best jury for you, which happened in this case. George Zimmerman and his lawyers hired a jury expert to help them pick the perfect jury, right? But just say that you can't strike any of those 6 people for cause because you haven't proved cause. And also say you've gone through all of your preempts, right? So you have nothing left. You can't strike any more people. You can still object to that jury. And you can object by saying, I do not believe that this is an accurate representation of the public. It's all white and it's all women. That is not an accurate depiction of this person's peers, and the Constitution allows them and affords them the protection of a fair trial, and I don't believe this is fair. Either side can make that objection. So I don't know why the district attorney did not object to this jury. So after voir dire ended and they had their 6-person jury of all white women, motions in limine were concluded. Now, motions in limine are a bunch of pretrial arguments. You go in front of the judge, and like I've said before, if you listen to any of these other videos, motions in limine pretty much are going to set up your defense. It is the guideline of your trial. The big stressor about motions in limine is that you usually do not get rulings until the day before, the day of, or even the middle of trial. So you have no idea how your case is going to go. You really don't. You have to prepare for so many different strategies and so many different arguments because you don't know what's going to be allowed in or what's not. So in order to understand the arguments of the motions in limine, we have to do a little bit of backstory through investigation. And usually I bring out this investigation during the trial, right? I don't ever sit here and act like a true crime podcast and go over the investigation because I want you guys to see how this evidence is discovered through the litigation process. Because when you're a jury member, you don't know the investigation. You can only find out what you're being told in trial. That's why I like to do this podcast, to show you how juries can kind of get to the conclusions they get to, because they don't have all of the evidence or all of the information as somebody that's watching the news, right? The reason why we have to go into this backstory is because this evidence wasn't allowed in. So we need to first understand the gated neighborhood that George Zimmerman was living in. He was living in a gated neighborhood called Twin Peaks. This was in Sanford, Florida. And at the time of the development of this neighborhood, people that bought these townhomes bought these homes at the height of the market, right? So this neighborhood was predominantly, like literally over 85% white, and of the upper middle class to low high class tax bracket. Well, what ended up happening was, as we all know, there was a recession, the Great Recession, I think it's called. And the housing markets crashed, and they have never crashed this hard before. And what ended up happening was a lot of these people in this neighborhood, in George Zimmerman's gated neighborhood, they ended up filing for bankruptcy. They ended up not being able to pay the mortgage, and the bank took over these homes through foreclosure. And what ended up happening was that the banks worked out a deal with the government, like with the county, and they were able to get funding to pay off the loans of these townhomes that these people owed money on, as long as the homes went to low income housing, which this actually happens a lot. A lot of buildings that get aid from the government basically says, okay, we'll help you out and we'll give you this money, but you have to allot X amount of your units to low income housing and to Section 8 housing, which is what happened here. So a bunch of people from Section 8 moved into this gated area and started living here. And this just pissed off all of these rich white residents that remained, right? And so a bunch of people of color had begun moving in. People of color that were either with Section 8 and low income, or just people of color in general that didn't get any housing subsidies, but they decided to buy some of these condos and these townhomes because the price was so good that they were going to make a huge benefit. By the time that the housing market picked back up, they would now be able to sell these homes for like triple, quadruple what they had already paid for. So a bunch of people were coming in, and it just so happened to no longer be a white area. So the neighborhood also became victim. A bunch of break-ins and a bunch of burglaries and a bunch of robberies had now begun to ensue throughout the Twin Peaks gated neighborhood. And all the old residents that remained there from before the recession basically said it was all the people of color that were coming in through Section 8 that were creating all this crime and all this havoc. So in literally just a short amount of months, it was like between the months of October of 2011 to February of 2012, George Zimmerman called the police department 50 times to report suspicious Black people. And let me tell you what some of these calls said on why these Black people were allegedly just so suspicious. There were about 5 to 6 children between the ages of 10 to 12 playing in the streets. They were running in the streets, playing tag with each other. And George Zimmerman called and reported this as suspicious activity because it had become a habitual problem of these children playing. He also called the police on October 1st, 2011, and he wanted to report 2 suspicious people, right? And so the police were like, okay, well, can you describe why they're suspicious? And he says, yeah, they're 2 Black teenagers and they're hanging out near the gated community. Were they in the gated community? No. Were they breaking in? No. Were they trying to climb the fence? No. They were just near proximity to the gate and they were Black. Then on February 2nd, he called to report a suspicious Black man. That is what he said. I'm calling to report a suspicious black male. And the cop said, okay, well, what's happening? Why is he suspicious? And he said, well, this Black male is suspicious because he's walking in my neighborhood. So the district attorney also got evidence from another 911 call. There was an anonymous caller that called 2 days after Trayvon Martin died. And it's a woman, and you can hear her recorded call. And she's like in hysteric and she's desperate. Like you can hear the emotions in her voice on how desperate she is. And she is telling the police, look, I don't know what happened that night that young boy was killed, but I know George Zimmerman, and George Zimmerman is a racist and he hates Black people. I know him. I know he did this on purpose. He killed that person on purpose because that person's Black. He hates Black people. And she was saying that there's all these recordings of him saying the N-word, of also saying that Black people should not be called Black people. They should be called monkeys, and all these other obscene recordings. He was begging them. She's like, look, please just investigate him. You're going to find so many people that are going to tell you exactly what I'm telling you. You just need to find someone that's not scared of him. I'm terrified, so I don't want to give my name. So the judge that heard these arguments for the motion and limine arguments, her name was Deborah Nelson. And she ruled literally right before opening statements came, literally like minutes before opening statements, she ruled that none of this was allowed in, that the district attorney was not allowed to bring in any evidence of race, of racial profiling, of racism, that she couldn't mention racial profiling. She couldn't basically insinuate that George Zimmerman was a racist and that's why this had happened. She couldn't insinuate that George Zimmerman thought he was suspicious because he's Black. The DA couldn't insinuate that George Zimmerman stalked him, got out of his car and followed this young boy because he's Black. They couldn't do anything about racial profiling, which completely gutted the prosecution. In that moment, the prosecution lost. Like completely lost. If it was me, I don't know what I would have done, to be honest, because double jeopardy applies the second a jury is sworn in, and the jury was already sworn in, so you can't dismiss the case. Because if you were to dismiss the case and try to do new chargings, it would be thwarted because double jeopardy has attached the second your jury swore in. And the reason why it is completely gutted is because in the state of Florida, for second degree murder, you have to prove ill will, hatred, and spite. In Florida, you have to prove that to get a conviction for second degree murder. And now that they can't bring in racial profiling or the fact that they have all this evidence that George Zimmerman is a racist, they can't prove ill will. They can't prove spite. They can't prove hatred. They can't prove any of that. All what the evidence is going to show now was that there were burglaries within this homes and within this area, and that George Zimmerman was a concerned citizen that called the police. In the motions in limine, the judge also ruled that the defense was not allowed to use the evidence that they were trying to bring in of Trayvon Martin's school records that showed that he got into several fights at school. They couldn't bring in evidence from his school records that he had been suspended for marijuana use 2 weeks before he was murdered. And they also couldn't bring forth evidence that Trayvon Martin knew and was familiar with guns. The defense also requested if the jury could go and view the crime scene. The judge also denied that as well. So there was another very important ruling in these motions in limine that had happened. If you remember Benjamin Crump, who I just mentioned, he was the civil rights attorney that the Martin family had hired, right? And he was the one that really got this case going. He was essentially the one that was able to get the prosecution to ever file charges against Zimmerman. And he was also the one to get evidence released. So he was like a force to be reckoned with. And he was pretty much helping the district attorney the entire way through with strategies, with objections, with ideas, with motions in limine, with the public, keeping the public updated. And what had happened was the defense attorneys put him down as a last minute witness. They told the judge, hey, we may call Benjamin Crump to the stand. We're not positive, but we may. And the law, right? The law states that we have to overturn every witness we may or may not call, that we reason believe we could possibly call to the DAs. But essentially they're like, hey, we may or may not call him, but because he's on our witness list, the rules of evidence apply, meaning he has to not be here. He is not allowed to watch the trial, which is true. If you are a witness or a potential witness to testify, you're not allowed to sit in and watch the trial. The only way you're allowed to is if you're the victim's family member, right? Like the mom, the dad, the grandparents, some immediate family member, and your child, your person was the victim. The reason why is they want to protect the testimony. They don't want your testimony to be influenced by what you're hearing other people testify to. So the defense just used this as a huge strategy, and they pretty much admitted to it that it was only done for tactics because they knew that he was going to be able to help the prosecution and potentially win the case and get their client convicted because he was that good and he was in the DA's ear. So now they had removed him from that situation. So on June 24th, opening statements began, and DDA John Guy, he was the district attorney because there was two of them, but he was the district attorney that gave the opening statements. And I do have to admit, this was probably the best opening statement I have ever heard from a district attorney. He was very, very skilled at opening, and he was very skilled at closing. The rest of it, it's rough, very rough. But I do want to read to you part of his opening statement. His opening statement was about 35 minutes long, which I believe is slightly short for a murder case. But at the same time, you know, a lot of their evidence was gutted 5 minutes before he gave this opening. So I don't know how much you can actually talk about. This is how he starts. Fucking punks. These assholes, they always get away. Those were the words in that grown man's mouth as he followed this child in the dark, as he followed a 17-year-old boy he didn't know. Fucking punks. These assholes, they always get away. Those were the words in that man's chest when he got out of his car, armed with a fully loaded semi-automatic pistol and 2 flashlights to follow on foot Trayvon Benjamin Martin, who was walking home from a 7-Eleven armed with 23 ounces of Arizona brand fruit juice and a small bag of Skittle candies. Fucking punks. These assholes. They always get away. Those were the words that defendant had just moments before he pressed that pistol into Trayvon Martin's chest and pulled the trigger. And then as the smoke and the smell of that fatal gunshot rose into a rainy Sunday Sanford night, Trayvon Martin, 21 days removed from his 16th year, was face down in wet grass laboring through his final breaths on this earth. And that defendant at the same time was upright, walking around, preparing to tell law enforcement why he had just profiled, followed, and murdered an unarmed teenager. Ladies and gentlemen, the truth about the murder of Trayvon Martin is going to come directly from his mouth, from those hateful-filled words that he used to describe a perfect stranger, and from the lies that he told to the police to try to justify his actions. If you indulge me for the next few minutes, I would like to share with you a little greater detail of the end of Trayvon Martin's young life and the overwhelming evidence of the defendant's guilt of the murder of Trayvon Martin. This murder was the product of two worlds colliding, and one world was a 17-year-old boy from Miami, Florida, a visitor to this town, who had gone to the store to get a drink for himself and some candy for a 12-year-old friend. But in the other world, a 28-year-old grown man, somebody who wanted to be a police officer, somebody who called the police numerous times about crimes in his neighborhood, someone who had become the neighborhood watch captain, and someone who believed most importantly that it was his right to rid his neighborhood of anyone that he believed didn't belong. So this opening statement was beautiful. It was perfectly done. It was an incredible opening statement. As you can hear, he mentioned profiling. He was allowed to mention the word profiling, but he was not allowed to mention the word racial profiling. And he could mention evidence, he just couldn't mention any evidence of race. So what ended up happening was that it turned the prosecution's case from a racist person that's profiling black people because he believes that black people are these criminals that are targeting and terrorizing all these white people into this was a crime-ridden neighborhood, and this guy was upset about the terror that was raining down, so he was trying to profile and find people to protect his neighborhood. It changes the story a lot. For opening statements, they're all about you telling the jury what you believe the evidence is going to show, right? That's all what it is. It's not an argument. It's just what you believe the evidence is going to show. So the district attorney tells the jury what he believes the evidence is going to show, and he says that there's absolutely no evidence that's going to show that Zimmerman was in fear for his life of Trayvon Martin, that Trayvon Martin was not armed, all he had was Skittles and a candy, that the evidence was going to show that Trayvon Martin wasn't acting suspicious at all, that he was literally just walking from the store back to the home and where he was staying with his dad and his dad's fiance. And he said that the evidence was also going to show that Zimmerman was lying about being in fear, that there was no evidence that his head was being slammed against the concrete because there was no blood on the concrete, and that the lacerations on his head, it was one laceration that was 2 centimeters, and that is not consistent with blunt force trauma of having your head slammed against the concrete. The district attorney also said that the evidence was going to show that Zimmerman was lying, that Trayvon Martin had punched him numerous times, because the evidence shows that there's a complete lack of bruising and swelling or redness to Trayvon's hands. He also said that the evidence was going to show that Zimmerman was lying when he said that Trayvon reached for his gun because they did a DNA test on the gun and there was no DNA of Trayvon Martin. So Don West gave the opening statement for the defense, and I have some things to say about Don West. The first thing I have to say is that he was by far, both defense attorneys were really good. Marco Mara and Don West were both very, very good defense attorneys. I do think Don West kind of came out on top. He had the harder hitting statements and the harder hitting cross-examinations, and he really really kind of made the defense for the defense. He made the case for the defense. So Don West was actually a deputy public defender, a federal deputy public defender, his whole career. And he only left the public defender's office because Mark O'Mara called him and asked him if he would please join him on this case of representing Zimmerman. And he said yes. So he left the public defender's office in order to do this case. And Don West specifically, he was just a master in opening statements, closing arguments, as well as cross-examination. But that's because he was a public defender. We live and breathe this shit every single day, right? But what I will say, he was very crass. He was very inappropriate. He would be laughing and looking smug throughout this whole trial. I really did not have much respect for him for that aspect. I understand even as a public defender that I have a job, and there may be a point in time where I have to represent somebody like George Zimmerman. Probably not, because those kind of people don't come across the PD's office very often. But I understand that everyone has a job. But there is a way to do your job and still be tasteful. And I don't think he was tasteful. I'm saying that because I usually don't give opinions in these, but Don West gave the opening statement for the defense in the most crude way possible. He started with a joke, a literal knock-knock joke at a murder trial. A 17-year-old boy was murdered, and he started his opening statement with a joke. He goes, knock, knock. Who's there? George Zimmerman. George Zimmerman who? All right, good. You're on the jury. It was bizarre. It was memorable, but it was bizarre. Saying that he believes the evidence is going to show that this was a crime-ridden neighborhood and that there had been several break-ins and several people have been burglarized, robbed, all of these things, and that George Zimmerman was, just protecting his community. And on the night in question, he said that the evidence was going to show that it was actually Trayvon Martin who was the aggressor, and it was Trayvon Martin that was chasing down George Zimmerman. Trayvon Martin ended up sucker punching him and slamming his head against the concrete multiple times, almost killing him, and that Trayvon Martin went to actually grab his gun and kill him because hitting his head against the concrete wasn't like getting the job done, right? And in fact, even in his opening, he literally says this. He says that Trayvon Martin was not an unarmed teenager. Trayvon Martin was armed that night with the sidewalk. And he says that while holding up a piece of concrete. And with that, the court is going to take a brief recess on the People versus George Zimmerman. Make sure to follow along for part 2 to hear how the People versus George Zimmerman ends. And for now, the defense rests.